In 1 minute and 30 seconds, we're gonna start. I think this is very important right now. It got cold. Cold. What's up, family? What's up? What's up? Well, it's getting cold. Man. Oh, shoot. Oh, it's kind of cold. What's going on? What's going on, family? How y'all doing? What's up? ABNs for life. How you doing, family? What's going on? We're going to start in 30 seconds. How y'all Sunday morning going? What's up, Mark? What's up, bro? What's up? What's up, family? What's going on? 20 seconds, we're going to start, family. What's up? What's up? What's good? What's good? Yes, sir. Yeah, I've been busy a little bit, family. What's good, family? How y'all doing? So in 6 seconds, we're gonna start. We're gonna start. 3, 2, 1, go. All right, cool. So how y'all doing, family? So look, today we're gonna be talking about something serious, right? Now, I've seen this been the topic of the discussion. A lot of people have been saying, representing yourself is a bad idea, or or whatever the case might be. Now, this is my personal opinion about going pro se versus having an attorney, right? Now, I'm gonna be honest with you, right? It's 2 reasons, right, for the whole thing, right? Now, you got representing yourself and you got an attorney. My personal opinion about the whole thing, for me, I would say pro se, right? Because this is what a lot of people overlook, right? Because I talked about this before, right? But let me talk about the pro se side and let me talk about the attorney side. For going pro se, you got to understand this. The only person that know the true and actual details of your case is you. Meaning, you know what you said, like as far as statements. You know exactly what happened or what transpired, seriously. You actually know who was involved, how many people was involved, and you know what took place and what didn't take place. And you also know what wrongs you made and what wrongs the officer made as well, right? So with that being said, an attorney is only looking at, say for instance, the discovery. So when they look at the discovery is ex parte. It's only one-sided. So if you watch any discovery, right, or if you see any police report, it would say, hey, we were traveling around and we seen this vehicle. The person was swerving left to right. We pulled the person over. They smoking a blunt and we asked them for ID. They said, fuck you. And they was not listening to us. We told them to step out. They said, hell no. And they showed us a gun and we pulled them out, right? So that's what the police report is saying, right? But when you actually look into the facts of what the defense saying, you will find out that the defense and the police or the state attorney both saying contradicting things, because that's not entirely what happened, right? And so the only person who will know the true facts of the or basis of the case is the person who actually fighting the case. So if you have an attorney, they can look at everything as far as your case, but they don't know every little detail how you would know it, right? Now, another reason why I say representing yourself is always better is because being represented by an attorney is very time consuming and expensive. So if you're in a position where you fight, let's just say an armed robbery, right? So if you find an armed robbery case and an attorney say, hey, I want $15,000 for this case, and you just sitting in jail, right? You might be sitting in jail 3-4 years before they even call your case, right? As far as calling it to trial or anything like that. So you couldn't depend on an attorney to file a motion to suppress or filing a motion to dismiss within the time frame that you want it to be, right? So as many people who stuck in jail with attorneys, and there's no way for them to get out because, number one, they don't know how to represent themselves. Another reason time being is they have to pay so much money. So if you got to pay $20,000 and you still in jail, and your case been supposed to be went to trial, especially by you representing yourself, that's another reason to represent yourself, right? That's another reason. So let's just say another reason to represent yourself. You find some sort of constitutional loophole that's beneficial for your case, and you can use that as your defense, right? So by you using that constitutional, defense as your defense that you're gonna use later in trial, that can be used by you. Now the attorney might find that later down, but it's like it's only time consuming, right? It's like everything is on. They trying to stretch everything out, but for you, it's a time schedule. You might have a family, you might have kids, and you don't want to be away from your kids 4-5 years until they decide what's going on with your case. Another reason why you want to represent yourself, because you have a constitutional right under the Second Amendment to a fast and speedy trial. A fast and speedy trial will allow a defendant who's sitting incarcerated to go to trial within the first 90 days of their arrest. So the moment you get arrested and you say you don't want counsel, you could demand for a speedy trial the first day you get incarcerated. That means the exact day, like say if someone arrests me, right? Let's just say I got arrested for a quadruple homicide, right? Me. Now, an idiot will drag out the case for 10 years, and the police and the prosecutor will build an entire case on you, right? And the whole entire case, witnesses who don't even have anything to do with this case will come to court because you allow so much time to take place. So when you have an attorney, when you sitting on 4 murders, you have to drag that out. That takes 4-5 years to fight. But if you understand law and you understand certain motions, and you understand certain legal ramifications, you will exercise your Sixth Amendment right for a fast and speedy trial. That means if your state, like let's just say Ohio requires that the state bring you to trial within 90 days of your arrest. So the first day in your bond hearing, if you say the defense demands for a speedy trial, you can orally say that. And once they place it on the record, it's set for trial within 90 days. Now, you as a pro se litigant or a pro se person, you got a duty and an obligation to research your case, research the facts of your case, research the DNA evidence. You have the duty to look at the discovery, cross-examine the discovery, look over the witness list, look over any added witnesses that they plan on using against the case, check and see if there's a murder weapon that's involved. You can do all the due diligence within your own case. And remind you this, you can actually go ahead and fight your case the correct way. So now you know all the details in your case, and you also have the right to a speedy trial, so you're not dragging anything on. So with an attorney, you sit in jail 5-6 years. And then they be like, oh man, yeah, we can't beat this case. So it took you 5 years to tell me we can't beat this case. Because understand this, you not your attorney only client. And that's the benefit of the doubt that I would give an attorney. Because the attorney working on hundreds of cases, maybe thousands of cases. You're not the only case. And that's why so many people are sitting in jail right now, because their legal representation cannot fully and effectively represent them in the correct manner because they have so many cases themselves. So you also got to be mindful of it, right? So with all that being said, I'll pick pro se. Now, the flip side. Now, this is why I would agree for you to have an attorney. If you don't understand law, if you don't understand how to read a discovery, if you don't understand how to file correct motions as far as a motion to suppress evidence, or a motion even for something simple like a demand of speedy trial, or a motion to add witnesses to the case to testify on your behalf, if you're not familiar with any of these things and you can't learn fast as far as on the law side, I would suggest or recommend you to get an attorney, because most people don't understand how to actually effectively represent themselves. And on top of that, you also have to be emotionally mature when you go to trial. Now, a lot of people try to use the term, what's that term? They say a person who represents themselves has a fool for a client. That's absolutely false. And I'm gonna tell you why that's absolutely false. Because understand this, right? When another person is representing you, right, the jury don't even have the chance to know who you are. They only listen to what your attorney's saying. You know, when I went to Florida, and one of the main reasons of how I got found not guilty wasn't even the evidence, it was the person. When they found out who the person was, who the state allegedly charging, they read your body language. They trying to see if you're a good person. They look at certain movements and everything like that in the way how you conduct yourself during trial. So when a person is represented by an attorney, they don't know who you is. Let's just say if you got tattoos on your neck, tattoos on your face, and you charged with an armed robbery, you ain't saying a word in court, your attorney speaking everything for you. You don't think the jurors is looking directly at you to see if anything about you says guilty, guilty, guilty. due to your persona, due to them not even knowing who you are. Because remember, by you not representing yourself and you being represented, you cannot expect anyone to look at you in a better light than what you already is. Because if you fight in a certain case and you're not representing yourself, you're just quiet on the side. So they haven't got a chance to meet you. They haven't got a chance to even hear your voice. So you're just silent. You get what I'm saying? And I look at a lot of people who do go against people who pro se is also people who trying to make a lot of money off of people. You know, many attorneys will charge you $2-3 million an arm and a leg, and by you having an attorney, it's not no guaranteed win anyway. It's not always a guaranteed win. So you also got to put that in mind as well. So a person who does not represent themselves, you also got way more risk that comes with it. You have way more risk than what you think. Because by you not being able to represent yourself and you just quiet on the sideline and you know it's so much evidence against you, the attorney might could represent you nice, right? But it's always better and effectively when you represent yourself in any matter. That's my personal opinion about it. Because I've seen idiots who represent themselves and they arguing with the judge the entire time. That's not how you properly represent yourself. Understand this. The judge is not charging you for the crime. So why are you arguing with the judge the entire time when you go on the trial? You sitting back yelling at the judge, calling the judge stupid, and making all these remarks towards the judge as if it's the judge that's charging you with the crime. The only reason why judges would deny most of y'all motions is because y'all are not representing yourselves. Y'all go in court and argue. That's not representing yourself effectively. You have to file a pretrial motion. It's for a Faretta hearing. When you file a motion for a Faretta hearing, they do something called a psychological evaluation. And when they do a psychological evaluation, they pretty much trying to see, are you sane? Number one, can you represent yourself effectively? Your highest level of education as far as how you ever went to college, high school diploma, and etc. Another thing, what they do is they ask you, are you familiar with law? Do you know anything about law? Have you ever studied this? And then once you answer all of those questions correctly, and the judge see that you are deemed to be competent to represent yourself, then they will appoint you as attorney. Now it goes on the record. I did it twice. So once they appoint you as attorney for yourself, right, you represent yourself, now the position changed because now they got it on the record. And now once you file a motion, every motion has to be accounted for. So if you file a motion, they look through certain laws that matches your case, right? So let's just say, I'm going to give you an example, right? Let's just say for me, I went through a bond hearing motion. That means the attorney, the state's attorney, requested that my bail be increased. So we went to the bond motion. First, we had the preliminary hearing where I cross-examined the officer, and then after that, we had something called a bond hearing to see should they increase my bail because they upped the charge. But after we went through the preliminary, the judge got to see a surface of the case, meaning the details of the case, the facts of the case, certain testimonies from the witness, right? And once those witnesses was cross-examined by me, which will be the defense, the judge looked at the bond motion. He denied the state's motion to increase bail, and he granted the defense motion to be released from all bail conditions due to the circumstances of the case. So when you represent yourself effectively, you also have to put the motions in context. So you just don't write any weird stuff that you see on YouTube. You also have to learn how to speak their language, but at the same time, you still got constitutional remedy. Because one thing that I found out with how a lot of courts operate, they do use the Constitution, right? But this is what we're missing. They only use the constitutional law that the Supreme Court has ruled on. So the Supreme Court job is to interpret the law. So by them interpreting the law, right, anything that was passed by the Supreme Court was would be deemed constitutional, right, or unconstitutional, right? So in my case, I'm gonna tell y'all why my bail conditions was released, right? This is what I want to explain to y'all. When I asked the officer, right, and when I was cross-examining him, I asked him, Before the defendant was taken out of the vehicle, did you observe any contraband? He said no. Did you smell any cannabis? He said no. Did the defendant in any manner threaten you? He said no. Did you observe any weapons in physical range? He said no. Once you pulled the defendant out of the vehicle, you immediately searched him, correct? He said yes. And after you searched him, did you handcuff him and took him away from the vehicle? He said yes. Got your ass. Now, no, I'm gonna tell y'all how I won the case. So once he said that, right, I'm about to give y'all the case law that I found. And this the judge know that. That's why I'm gonna kill him in emotion. You got Arizona versus Gang. If y'all don't know this case law, understand it. When the police arrest you, right? I'm gonna tell y'all about the case, but let me give you an analysis of it. When a police officer arrests you and handcuff you and securely take you away from the vehicle, any searches beyond searching you immediately, like as far as searching the car and everything, like they search your body, but anything as far as further searching the car after they already took you away from the vehicle and handcuffed you and securely took you away from the car, that would be considered unconstitutional. You got United States versus Gantt. This was after New York versus Belton, where the Supreme Court says the police can search your vehicle after they make an arrest. But the Supreme Court has revisited that Supreme Court decision of New York versus Belton, and they went into the Arizona versus Gantt, where a person was locked away securely from his car. When the police arrested him, they took him out of the vehicle, put him in the back of the car. Then the police officer proceeds to search his car, and they found a gun and they found some drugs. Now, Gantt was found guilty and sentenced in prison, but they motioned the case all the way up to the Supreme Court. When they motioned it up to the Supreme Court says once an individual is searched, right, and he's taken away to a secure area, what happened is the police would need a warrant in order to search the vehicle, and you kill him just with the motion like that. So when the judge told the officer, when he told the states based off the circumstances of this case, I'm gonna have to deny your bail, the case law of Arizona versus Grant had to be given to the court by the defendant. So I would have to make that motion to suppress all evidence and squash arrest under Arizona versus Gantt and show the legal terminology and how the Supreme Court interpret the law, because they can arrest you, they can't search your vehicle, especially for a suspended license, a regular, or not having a license. It has to be, you have to be investigated for a crime that, what am I about to say? So you have to be investigated for a crime, and like say if I had a warrant for drugs, they would have to search the vehicle for drugs or any evidence pertaining to the case. But in Arizona versus Gantt, Gantt was arrested for not having a driver's license. He was not arrested for having drugs or a gun. You get what I'm saying? So in that case, when they searched his vehicle and they found the drugs, the Supreme Court said that search was considered unconstitutional. So in my case, when the police grabbed me and took me out the vehicle and took me to a secure location, and you found a gun inside the car, you didn't find that on the person's immediate body. On the person's immediate body. So therefore, at that time, the officer's safety was not in jeopardy. So after you took me away from the car to a secure location, any further searches will require a search warrant. By you searching the entire vehicle, that was considered unconstitutional by the Supreme Court. That's how I'm going to win the motion. Yep. So you get what I'm saying? So that's how. So that's what you got to understand. You got to look at certain case law that was already that the Supreme Court made a ruling on. Yeah. Yeah, family. So that's one thing you got to look at. You got to look at, are you actually representing yourself, or you just one of the people who claim to be a sovereign citizen going to court just yelling at the judge? So you haven't even asserted your rights, your Faretta rights. You got Faretta versus California, where a person sued all the way up to the Supreme Court for the right to represent himself. So that's what's called your Faretta rights. So you have a constitutional right to represent yourself without having counsel. You get what I'm saying? Or counsel, however you want to say it. So you got the right to represent yourself. You just got to do it properly. You go in court, you don't got to say nothing. Once you're able to represent yourself, that's when you can challenge jurisdiction. You can challenge subject matter jurisdiction. You can suppress all evidence or squash arrest. You can challenge any evidence as far as if the search was unconstitutional, or you can challenge the search in so many ways. But you have to be at least representing yourself before you can do anything. The judge act like the state's attorney originally because, and most of the time, it's conduct. And it sounds like that, but it's conduct. It's how we conduct ourselves. So when I went to court personally, when my judge granted to release me of all my bail conditions, that judge was not biased. That judge was not acting like a state's attorney or nothing. Even the judge prior to him, they was not acting like a state's attorney. It's just the presumption that you are a ward of the state, and wards of the state should shut the hell up and let your attorney speak for you, or you should file a motion for a Faretta hearing. And sometimes you could do it like this. So say if you go to bond court, you get a bond. Let's say if your bond $1,000, you bond out, right? So you had an attorney for bond court. Now you go to the clerk's office, and your state should already have a template. Just search up Faretta hearing motion, right? And search up your county, and you should see the Faretta hearing motion. Put your name on the motion, type which date, sign the date that you filed on the motion. You don't got to put nothing really specifically in there, and take it to the clerk's office, put the case number at the top, file it on the record. The clerk going to ask you, when do you want to schedule your court date? Say I want to schedule it for the next following day. Once you schedule it for the next following day, they're going to say, hey, Mr. Williams, let's just say it's me. They're going to say, hey, Mr. Williams, you have filed a motion for a Faretta hearing. I'm going to say, yes, Your Honor, defense wishes to represent himself in this matter without counsel. They say, okay, are you ready? I'm going to say yes. And they're going to ask you the following questions that I said before. Are you experienced with representing yourself? What's your highest level of education? Have you ever, what else they're going to ask you? Have you ever been diagnosed to be psychological or suicidal or anything like that? Or are you an alcoholic or anything like that? And so once they ask you those questions, they're going to say, okay, the court's finding that you are very competent to represent yourself, and the attorney from your case will be discharged from their obligations. So they're going to call the attorney that's on your case, right? Because if it's a public defender, he gonna come. Like my public defender, he has to come up next to me and say, so do you wish to fire your attorney? I say, yes, I do. They say, okay, you are released from your obligations. And they say, Mr. Williams, you can represent yourself. That's it. And you got to do that for every judge you go to. So now I got a whole new judge. So I had to do the same thing. You get what I'm saying? So you got to do the same thing. And after that, you can do what, then you can file all the motions you want. You still gotta, because they under the presumption that you're supposed to have an attorney. You just talking. You get what I'm saying? So they under the impression that you have an attorney, that this attorney was assigned to you and everything like that. So instead of you doing the proper way, you just come to court talking. So by you not filing a Faretta hearing, they don't see that you trying to represent yourself. They just see that you are really trying to argue with the judge. Not one person. I ain't never heard of one person go in court, at least argue against the prosecution. Most people that claim this stuff all go in court, yell at the judge. It's like being in a boxing ring and I'm constantly swinging at the referee. You get what I'm saying? Because the judge is the referee. So you go in the boxing ring, he said, ready, said, fight, and you just start busting off the referee. Why the hell you busting off him? He's not hitting you. He's not swinging nothing at you. You get what I'm saying? But it's just people crazy, you know? You know what I'm saying? So yeah, so you just swinging off the judge, just knocking his head completely off because of what? I honestly don't know. I honestly do not know why so many people go in court and they argue against the judge, and they scream at the judge and they tell the judge, "Oh, you don't have the judicial obligations to do this." You listen. You can challenge the subject matter of the case, but at least be representing yourself. A Faretta hearing does not grant the court jurisdiction. You just only making a motion to represent on your behalf of any matters that is brought to you before the court. So if you want to represent yourself, you can. It just got to be done in fashion. It's got to be done in order, and everything has to be followed as procedure. And once you represent yourself effectively, then you can file any pretrial motions that you want. I told you I've been to court 5 times in 1 month. And this was I want to say this was between like August and early September until he released all bail obligations. You get what I'm saying? So I always had to go. I kept going to court. And what's so good about representing yourself, you can schedule your own court dates. You can demand for a speedy trial whenever you want. You can file a motion to dismiss 1,000,000 times. You can file a motion to suppress evidence 1,000,000 times. You can go to trial anytime you want. You can delay the case for however long you want. You can call whatever witness you want that's relevant to the case to court anytime you want. You get what I'm saying? So these are the pros of representing yourself. Having an attorney is good if you don't know law, if you don't understand anything. You're just going to have to rot in jail because it is expensive to be ignorant and it is free to be smart. Because the law library is free. Knowledge is free. It's given to us. You get what I'm saying? But like to be ignorant, yeah, it costs a lot of money to be ignorant. If I didn't know how to file a motion, matter of fact, I already have a motion to suppress. I already got a motion that was written by my standby counsel last year. I'm actually gonna post that motion one day. But this motion on this case that I'm about to make, I'm gonna show y'all that motion, but it gotta be granted first. Once it's granted and they squash arrest and they suppress all evidence and they close the case, that's what I'm gonna show my motion. Then I'm gonna show y'all how to properly file a motion to suppress evidence. That means you can show can you mention the Constitution the entire time? It's just a certain way how you word it. You get what I'm saying? I'm gonna read out a motion to y'all one day. I'm gonna read out a real motion to y'all to show y'all exactly how to write a motion. Yeah, that's cool, yeah. Yeah. Just like that. Bad Apple Media, that's cool. Is the judge neutral and why is the judge objecting for the state? What you mean, objecting for the state? Now, I don't know the circumstances, so everybody case different. So a lot of times when you will see the judge objecting whatever you're saying, it's because sometimes you're saying anything out of context. So if you're talking a whole different language, to them it's just like, what is he talking about? Certain things cannot be addressed, especially if other things hasn't been addressed. Like you're not representing yourself, you come to court, you got disorderly conduct and things like that. Like you don't even conduct yourself in the right way. You don't even respect. You don't even have the level of respect. When I go to court, I respect the judge. I say, Your Honor, I respect him. Same way he respect me. That's why everything going in my favor. I don't show disrespect. I don't go in court just screaming at the judge. You know how long my hearings last? 30 seconds. 30 seconds. And I do a Zoom call. I say, hey, how you doing, Your Honor? And he said, hey, and that's it. And keep it going. Prosecution don't say nothing. It's respectful. Because at the end of the day, I got the law on my side. I got the truth on my side. I got the Constitution on my side. I got Arizona versus Gantt on my side. Unlawful searches and seizures on my side. So what the hell am I finna go in court and argue against all this for? And I know I got the case beaten. You don't have to do all that. You could just be cool and making sure that you follow all procedures the correct way. You don't have to go in there with a certain hat or say anything. If you know you got it, you got it. You ain't got to make a fool out of yourself because we gonna be on those cameras. You know those because in Illinois we don't have those. Like when you be seeing people on live court and all that. Florida got those, right? Because it's a First Amendment state. But in Illinois we don't have that. So any proceedings is really like private. Yeah, like all that stuff really be private. But you don't want to be on those things when they say sovereign citizen make a fool out of himself in court. You don't want to be like that. I want them to show my court videos. That's why I wish Illinois was a First Amendment state, because I want them to show my videos. I want them to show that the judge object the state when I talk. Because when I was cross-examining the officer, I was like this. I told him, I said something. I said a couple things, right? So when I was asking him certain questions, the prosecutor was like, he said, objection, Your Honor. The judge said, overruled. Overruled. Your objection is overruled. He told the state, your motion is denied. he told the defense, your motion is granted. You see what I'm saying? So all that screaming and hollering, going to court, you ain't got to do all that. Just be calm, have respect for the next person. Because once the judge see the facts of the case, you can beat it just like that. Either the facts or even the constitutionality. Because certain facts might take a place. So let's just say if a person had cocaine in his trunk, right? Okay, we can argue, you can say that it's a fact that the person had drugs in his car. But was his rights constitutionally violated for you in order to even search the vehicle? If it's a yes, then he has the law on his side. Therefore, all evidence must be suppressed and the case must be dismissed. And you must squash arrest due to unlawful searches and seizures. Because a lot of factors that take place in this is violating your Fourth Amendment right. And the Supreme Court been ruled on that. It just depends on your circumstances. So I have to look at your case, look at the circumstances, and I'll tell you what's going on. No, I can record, like say for instance, Illinois, you can get all of your proceedings recorded, right? But it's not public, like it's not in the news. You know how they be finding people like stuff like court hearings? They literally be going to like Michigan and looking at all their court records and they just find it like that. And they call everybody a sovereign citizen. That's crazy. Anybody who represents themselves, they call them a sovereign citizen. Not one time in my case have I ever been called a sovereign citizen. Not one time. So the first time I called a case, ain't nothing like right now. Because me catching the case right now was way different from back then. Because back then they had way more evidence on me. Back then, I was not that sharp when it comes to understanding how the court proceedings work. I didn't have enough understanding of how everything was. But right now, it's a whole different ball game right now. You get what I'm saying? Yeah. Yeah. Judge got to follow law too. The judge got to follow the law. So anytime that your constitutional rights is violated, instantly squash and arrest. The judge can ignore them. He could try. No. You gotta. Yeah, I know. That's what I'm saying. And most people got bad conduct too. So when I be looking at those videos, like, people trying, but I feel like that it's their conduct that's make the whole thing bad. It's how they act. It's how they represent themselves in court. It's how the disrespect that they have. They don't even have respect for the next human being. You don't call your doctor anything like a byword. You get what I'm saying? You respect your doctor, right? But when it gets to the room, you can't even call a judge or your honor. You gotta call him a damn ward, or you get what I'm saying? Like disrespect, and like it'd be crazy. And I'd be like, what the heck? What's up, family? How you doing, Michael? Yeah, like, you want to have respect for the next person because they're going to have respect for you. That's why the judge was able to hear my case. He heard the circumstances of my case. He heard certain facts in my case. He heard the constitutionality in my case. He heard everything. Yeah. Yep. Yeah, family. So, that's how it is right there, family. But, yeah. All right, family. Finna leave right now. I'm out. Peace and love. Hope y'all take this advice. Hope you get some information from it and everything like that. I'm out. Peace and love to everybody.